Sanwanani Timilan, good evening and welcome to episode 242 of the Private Property Podcast. I'm your host, Uzamandungwa Khumalo. It's a Monday edition of the Private Property Podcast, and we're starting off the week just the only way we know how to, and that is, of course, tackling a property issue that will help us make the best property decision. But before we get started with our conversation this evening, you know I love talking about the other great shows that you can catch across the Private Property social media pages. If you're not following us already, do make sure that you follow us across our social media platforms on Facebook, on Twitter, on Instagram, as well as on YouTube. And you can follow myself at Zamantungo_K on Twitter as well as on Instagram. And of course, every Monday and Friday, a show that you can look forward to, especially if you are in the market for a new property, is the Home Shoppers Show with Chad, where he takes you through gorgeous properties that you can certainly salivate over, and of course give you a sneak peek of what is out there in the market. Every Tuesdays and Thursdays, award-winning farmer Umbali Noko brings you the Farming Podcast. And if you have an interest in agriculture, regardless of where in the agricultural landscape or value chain you want to delve into, that certainly is the show that you want to make sure that you tune into. Umbali is a farmer herself and has first-hand experience of some of the challenges that farmers face on a day-to-day basis. And every Wednesday, Esty Claassen brings you the First-Time Home Buyers Show, and that is one that you can look forward to if you are in the market for that first property and looking at different ways you can grow your property portfolio. She's always in conversation with people who've made strides from buying that first property and have now gone on to increase or certainly grow their property portfolio as much as possible. And of course, there's myself, Zamantungo Khumalo, every single weekday at 7 p.m. I'm always in conversation with an expert where we tackle a property issue that helps us make better and more informed property decisions. And it doesn't matter whether you are a tenant, whether you're a landlord, you're looking to buy, you're looking to sell. This is the property show that you want to make sure you are always plugged into. We speak to all kinds of experts, from your attorneys to your estate agents to different industry leaders, and really do cover every aspect of the property sector as much as possible. And of course, we focus primarily on residential property, as many of us tend to tackle residential property a lot, whether in our primary residence or, of course, when we are buying residential units to let out. And that's precisely what we're going to be exploring this evening. This evening, we're looking at 5 things that you need to consider when buying a property with an existing tenant. Now, I know that a lot of, property investors who currently have tenants, some of them are looking at offloading some of their properties, whether it is for financial reasons, whether it is to create a bit of liquidity in your portfolio, or perhaps there's another deal that you're eyeing and you really do need the room, and as far as affordability is concerned. And that particular property very likely has a tenant in place. So what are the do's and don'ts when you are selling a property that has a tenant in place? And on the upside, what happens if you are buying a property that has a tenant in place, especially if you either A, want to stay in the property yourself, or B, if you want to make sure that you retain that tenant. We're going to be looking at what you should and shouldn't do, because I know so many people tend to not know what to do with the tenant. Some people want immediate occupation. And so those are some of the things that we are going to be exploring this evening. And to help us best understand and make the right decision, because we never want to be on the wrong side of the law, especially where property is concerned, I'm joined this evening by Marius van Rensburg, who is a partner at Schindlers Attorneys. Marius, good evening, and thank you so much for joining us this evening.
Thank you. Thanks for having me again.
It's always such a pleasure to have you, Marius. I think let's get into it. And I was saying to you off air that I'm in this particular situation. Luckily, I know what some of the do's and don'ts. So the majority actually of the do's and don'ts are. I was very proactive when it came to the particular property that has a tenant that is for sale, where I had a conversation with my tenant before I even listed the property. So when I was still thinking about potentially selling the property, actually said, listen, I'm thinking of putting this property up for sale. I haven't made a final decision yet. I'll decide. And once I do, I will let you know. And I'll also keep you, updated in terms of the estate agent I'll be working with so that they, get your contact details for access and all those kinds of things. But I know that not every landlord, takes such a proactive step, Marius, and which is quite unfortunate because you end up even having access issues where tenant, isn't giving, whether it's a estate agent or certainly people who want to view access. So let's first start with when you are a seller and you are selling a property that has a tenant in place. What are the sort of do's and don'ts when you are about to sell your property or put your property up on the market and there's currently a tenant in place and there's a lease agreement in place?
Yeah, I mean, I think that your point is actually well made, and I often get a call from a seller, or I get a call from an estate agent, and they tell me that they're trying to sell a property where there's a tenant in the property, and then they're having problems with access, and there's a reluctance on the part of the tenant to cooperate because they have fearful that they may be thrown out the property, or they'll get a new landlord who's not going to be as cooperative. And under those circumstances, I always tell people that the old expression, you catch more bees with honey is always one that applies here. And that applies to any tenant problem, actually. Engage with your tenant, first of all. And I suppose the first thing you should do is ask the tenant if they want to buy the property, because that might make an easy sale for you.
Definitely, yeah. I think that actually, I want to interject there, Marius, because I actually did ask my tenant that when I was still thinking about it, with this particular property, they've been living there for, I think it was over 2 years. So they're very familiar with the property. And I said, listen, if you want to buy, this is the relative price point I was thinking of. I haven't made up a decision. I'm still in the very early stages of contemplating this. So think about it. Let me know. Once you've also let me know, I'll see where I'm at. And if I'm still going ahead and you're not interested, then of course we'll move it forward. So that is actually a great starting point, finding out from your tenant if they would want to buy that place, especially when they've been living there for an extended period and they seem to quite enjoy the place. That's definitely a great starting point.
Look, I mean, if your tenant wants to buy the property, it's an easy sale. And we as conveyancers, what I often do is I often draw up private sale agreements for clients under those circumstances. We normally don't charge for the agreement at all. We charge for the conveyancing, but that certainly is a good place. The next thing I think a seller must do is understand that the buyer that they find is either going to be a buyer who wants to move into the property and occupy the property themselves, or there's a buyer who doesn't want to move in the property but rather wants to take over the tenant. And really, I think a great starting point is get a copy of your lease agreement and read that lease agreement. Our courts have got lots of cases in front of them where landlords have sold properties to third-party buyers, and then they find out that there's a clause in their agreement, or there was something inserted in the agreement at the time that they put the lease in place, that they gave the buyer the first right of refusal. So it's always useful to take your agreement, look over the terms and conditions. Is your property the kind of property that's maybe decent for an investor buyer, or is it the kind of property where someone's going to live? Because of course, if you're selling a 2-bed, 2-bath property in 4 ways, which has got a tenant in, you're more likely to find an investor client than a different kind of property. And then you must look at the terms of your lease agreement. If your lease agreement is going to, if your lease agreement has just been renewed and it's going to run for another couple of months, then potentially, your market who you're going to sell to is a little bit limited, because you can only sell to an investor client unless the tenant wants to move out in the first place. Yeah, I think that what comes from a seller's point of view is and the steps they take depends largely on what kind of buyer is found.
Thank you there, Marius. Excuse me. I think flu season is sinus season is slowly getting the better of me during the show. And I think from our viewers at home, I certainly want to hear from you, whether from the buying side or the selling side, if you've ever found yourself in a situation where you are selling your property that has a tenant. Were you proactive in having a conversation with your tenant? As Marius, so rightfully points out, perhaps the first person you should be talking to about that sale is your tenant, and not just informing them that you plan on, selling the property, but also asking them if they'd be interested in buying that particular property. So that tends to be a very good starting step. And on the, buyer side, have you ever bought a property that had a tenant in place, and how was that experience like? Because I know it can be nightmarish sometimes, because there tends to be issues, and we'll deal with this slightly later, Marius. When you've bought a property that has a tenant in place, does the owner then make sure that they give the deposit over to you? I've seen that that's one of the things that tends to be forgotten in the transaction, and you inherit a tenant, you know that this is the lease agreement, but you never got the deposit from the previous owner. And now by the time when the current tenant wants to move out, there are issues around the deposit. But we'll get to that shortly, Marius. Let's now switch on over to you are a buyer and you are looking at buying a property and it has a tenant in place. And let's assume you want to inherit the tenant. I think, what are the steps in the event where you're clear that you are buying an investment property, and so you have no ambitions of trying to stay in that particular property?
So I think that the first thing to understand is, one needs to understand very clearly the principles of hier gaat voor koop. And what that really means is that if I'm going to buy a property with an existing tenant, there's a lease agreement, whether it's a verbal lease agreement or a written lease agreement, between the existing owner of the property and the tenant. When I buy that property, on the day that I become the registered owner in the deeds office, I assume the position of the seller as landlord, and I acquire the rights in terms of the principle of hier gaat voor koop. I acquire the same rights that the landlord had against the tenant, and the tenant has the same rights and obligations against me now as what they previously held against the person who sold me the property. So what's really important here from a buyer's point of view is to get your hands on a copy of that contract. Do not accept any verbal assurances as to what that contract says. And just to give you a silly example, I did a transfer some years ago where I transferred the property, the buyer got hold of the tenant, only to find out that it was a 2-year lease agreement. The rental was about 7,500 Rand a month, and the property was worth about 2 million Rand. It was a Santon property. So now the buyer has got a property where they got the same rights as what the seller had. Now they're stuck with a 2 million Rand property in the middle of Santon, where they can only collect 7,500 Rand rent a month. They can't increase the rent because it's a fixed term lease agreement. Now they must, if you think about the levies and rates and taxes in Santon, he probably walked out with 2 or 2,500 Rand a month after paying those expenses. So it's a lesson learned. Get a copy of the lease agreement, study the lease agreement. And what you're looking for in particular is, you're looking for who is the tenant, what is the lease term, what is the rental, when does the fixed period of that lease end, what is the escalation, and does the tenant have a revocable or irrevocable right to renew the property? So in other words, the lease may be ending in September this year, but there's an irrevocable right on behalf of the tenant to renew the lease. So you must know you may have to live with the tenant for another year. And maybe that suits your purposes, but what you want to do is you want to understand it. And of course, the next question that arises is, what happens if there isn't a written lease agreement? Now, if there isn't a written lease agreement, what I would do as a buyer is I would insist that the seller provides me with a written lease, a written document containing the terms of this lease agreement. And I would want them confirmed by the tenant, because, unlike for immovable property sales, the leasing of immovable property does not have to be in writing. In terms of the Rental Housing Act, you have to confirm the particulars, and the proposed amendments that haven't come in yet were that it's going to be in writing. But right now, you can still have a verbal lease agreement. What I would want the landlord to confirm the terms of the lease, the rental, the period of the lease, the escalation points, whether the tenant is paying electricity and water in addition to the rental, or whether that's included in the rental. Those sort of strange arrangements. I'd want to go through the written lease agreement and the confirmed terms of the verbal agreement very, very carefully to understand what am I buying in this particular instance. The next thing that I want to do if I'm a buyer, and this is good advice for sellers and for buyers, is I want an addendum. And if people email me or they go to my website, there's an example of this addendum. And the addendum wants to record, first of all, there is a lease agreement in place. 2, that the buyer has been made aware of and is satisfied with the terms of that lease agreement. 3, that the buyer's conducted a due diligence in regard to whether it's a good tenant, a bad tenant, or the arrears. And 4, there's an instruction to the conveyancer to, on registration or transfer, deduct the rental, the deposit amount, and the pro rata rental, and pay that directly to the purchaser from the proceeds of the sale. And I inserted that clause for partly selfish reasons, because what I found in the past is I'll transfer a property. The seller will say to me, please don't mess with my money. It's trust money. You pay all the money to me. Once I have the money, I will pay the deposit to the tenant, to the buyer, and I'll pay the pro rata rent. And then some sellers, they don't do it. Now I'm stuck with a situation where everyone's phoning me. The buyers are happy because they don't have the deposit. Now we must try and chase all the parties. It's much easier if I control that as the conveyancer. So on registration, it's nice and clean. The buyer gets the deposit, pro rata rent, and a copy of, and they got a copy of the lease agreement. They got the tenant's details. They can literally pick up from where they left off. And just to be clear on this, I had an email from a client today who is going to be taking up a tenant in a cottage, and they said to me, please can I have a copy of please can you draft a session of lease agreement? And as I mentioned to you earlier, there's no session of lease agreement necessary. In terms of the principle of hier gaat voor koop, you simply take over the tenants.
We're on in conversation this evening with Marius van Rensburg, who's a partner at Schindlers Attorneys, and we're looking at what you need to consider when you're buying a property with an existing tenant in place. We are taking your questions and comments this evening, and we've got a comment from one of our top fan gang members, Howard Mugazani, on Facebook, who says, I make it explicitly clear that even though I'll be giving the current tenant preference to keep occupying, I need to get a vacant property on registration and re-procure the same tenants using my own vetting processes on the other conditions section of the OTP. In that way, I have a clean start with the tenant. And perhaps, Marius, I want you to deal with this, especially because you've just outlined how when you do buy a property that has a tenant in place, you inherit the responsibility that the previous, that the seller essentially had. So in the event like this, can you as a buyer say that you want a property that is vacant? And in the event where you want to, re-vet essentially the tenant in place, is that something that you're able to put as a condition on the OTP and that the seller will be able to meet as a condition?
Well, let's answer the question by looking at scenario 2, and I'll answer the question as we go, because there's 2 parts to the question that was asked. In scenario 2, now you're looking at a buyer who wants vacant occupation of the property, and in this scenario, it's equally important to get a copy of the lease agreement. And what I have sellers and estate agents sending me their lease agreements, and I read the lease agreement for them. It's one of the services that we offer. I read the lease agreement because, it's not good enough to go to the tenant and say, or the landlord and say, listen, how long is the lease for? And they say, well, we think the lease will end, around about May, June. Okay, so fine. So if we do a deal now and it takes, sort of 8 weeks to transfer, well, then the lease is going to expire, let's say, for argument's sake, at the end of June, and the tenant moves out and the buyer can take a vacant occupation. The difficulty there is, and this is the trouble, with people not looking at the details of their contracts. Sometimes you get a lease agreement, And yes, the initial period of the lease expires at the end of June, but the tenant has a right to renew the lease. And there's different forms of rights to renew. Some of them are irrevocable and some of them are revocable. So some of them, the tenant has an automatic right to renew their contract. And the last thing that we want to do is sell the property where the buyer wants to move in or occupy the property themselves. And then in the month of May, the tenant exercises the right to renew for another year. Now we're stuck with that tenant for another year. So I'm saying peruse the lease agreement again, make sure that it's going to terminate. If the lease agreement, for example, is going to run until next year or at the end of the year or a period that's unacceptably long, then we must approach the tenant and say, Mr. Tenant, we want to sell the property. We want you to move out. Can we do an addendum to reduce the fixed term of the lease agreement? Or can we do an addendum and can we remove your right to renew the lease agreement? Now we do an addendum between the landlord and the tenant, which is binding on those parties to ensure that when we transfer the property, there's going to be vacant occupation. And that takes a little bit of work. That takes looking at the lease agreement and studying the terms and conditions. What I advocate to buyers who because there's a fear from buyers who say, I don't want to buy this property because I'm afraid that there's going to be a mistake and the transfer will be transferred into my name and the tenant's not going to move out. And I'm dealing with a case like that right now. The tenant does not want to move out the property. That's it. And the conveyancers have transferred the property. It wasn't us, thank goodness, but we'll try and resolve the problem. What I do is I advocate what's called a comfort clause. And what that clause says is, one, the parties record there is a lease agreement. Two, the parties record the buyer is entitled to vacant occupation. And three, the conveyancers are instructed to register the transfer of the property only when it's been confirmed to the conveyancers in writing by the agent or the buyer that the existing tenant has vacated the property. So what that clause does, it gives the buyer comfort that the tenant's going to vacate it before we register. Now what we do is we lodge in the deeds office to come up on prep roughly on the second or last day of the month. We let the tenant move out, we get confirmation, and then we transfer. So that's how I advocate to buyers and sellers and agents how they deal with the scenario where the tenant where the buyer wants to vacant occupation. But to come to the question that was posed, can you renegotiate the lease on registration or transfer? Well, I suppose everything's negotiable and you can potentially do that, but you must bear in mind that you may be faced with a tenant who has an extended lease agreement and they may be happy to re-sign a new lease agreement with you. If you as a buyer approach that tenant and say, listen, I want to buy the property. If I buy the property, I want to sign a new lease agreement. So I want to vet you as a tenant and let's re-sign a lease agreement for a year or 2 years. And the tenant may say, great, I'm very happy here. I'd love to stay and I'm happy to do that process. But you can't force the tenant. It's a negotiation process because the tenant could equally say to you, look, I'm not signing a new lease agreement. I have my rights. Here, curve will apply, and I'm happy with my current lease agreement, and I'm going to stick to it. So to answer the question, yeah, you can renegotiate, but only with permission of the tenant. Failing that, you must arrange your affairs such that the lease agreement expires, and then you actually have vacant occupation yourself. You can go into property registration, do what you want to do in terms of fixing it up, and then you can sign a new lease agreement with the tenant of your choice.
So, Marius, then what happens in the instance where you were in the process or are in the process or had gone through the process of buying a property that had a tenant in place and you inherit that particular tenant because, of course, that's what would happen because suppose the lease agreement was only going to, expire 3 months post-registration for argument's sake. And once you've inherited that tenant, then they become a problematic tenant. And when you look at sort of the rent roll from the previous owner, nothing was incorrect. They were paying rent on time. So if tenant, what are some of the active steps can you take to resolve that matter?
I think, first of all, if you're a buyer who's going to take over a tenant, you must do your homework. You must do your due diligence. And you must ask the right questions. You must ask about the history of the tenant, ask about the behavior of the tenant. Am I buying a tenant who every other day gets fines for making lots of noise in the complex or keeping everybody else awake or having big parties. Ask those questions. Ask those questions of the landlord and potentially get the answers in writing, but do a due diligence. I mean, arguably, and I must say I haven't come across the situation very often, but arguably there's an obligation on your landlord to make some kind of disclosure. It's almost like a defect in the property. Like if there's a leaking pipes in the property or lots of damp, you could argue that the same applies to the tenant. If the tenant is a crazy man who never pays rent and who's a constant problem in terms of the body corporate, arguably there's a disclosure issue there from a landlord's, a seller's point of view as well. But once you've inherited the tenants and there's a problem, you are the landlord. You have the rights and obligations arising from the lease agreement, and you must deal with it. You must place the tenant in breach, or you must, if you want to do it the softer way, go and have coffee with the guy and try and catch bees with honey and try and resolve the problem in an amicable way. But you must take your legal steps or your negotiation steps.
More of your questions and comments at home this evening was to talk about what to consider when you're buying a property that already has a tenant in place. We've got three really great questions. I'll ask them one by one. Marius, coming through from Unkateko Ahape. The first question is, during the sale process, so from the moment when you accept the OTP till registration, where should the tenant pay rent to, the existing owner or the conveyancers?
I think that the existing tenant must continue to pay rent exactly as was done before, should pay directly to the seller of the property. And then you must have that clause in the agreement that upon registration or transfer, we will do a pro rata rental. So, for example, if the rental is 10,000 in a month and I register on the 10th of the month, well, then what I want to do is I want to allocate the 1st to the 10th of the month to the seller, and I want the right of the conveyancer to deduct pro rata rental from the 10th to the 20th of the month and pay that over to the purchaser directly, add together with a deposit. But I think it's better to continue to pay in terms of the current arrangements.
And actually the second question and the third question ties very well with what you've just said. The second question is, as a buyer, can I stipulate on the offer to purchase that the rent be paid to the conveyancers instead of the owner?
Yeah, I mean, I suppose you could. I think it's easier simply to say that the conveyancer will pay you the pro rata rent from the proceeds of sale, but it wouldn't be wrong. It wouldn't be wrong for the conveyancer to collect the rent either.
Okay, because then the last question speaks directly to that, Marius, and the last question is, who's responsible for the pro rata rental collection if the tenant hasn't paid rent on the month the property is registered, the new owner or the existing owner?
Well, that needs to be stipulated in your contract, because what you must remember that once we register a transfer and I receive the proceeds of sale, as a conveyancer, I cannot unilaterally deduct money from the seller's proceeds of sale and pay any other third party, including the buyer. It's the same story when buyers come to me and say, I'm moving this property before transfer, there's all these problems, please withhold money until the seller fixes them. I can't. Trust money is sacred money. On registration, unless there's an instruction, I pay the seller. And that's why the instruction and the offer to purchase as to exactly what the conveyancer is authorized to do is so important.
And Marius, as we close this conversation, because I think it is one of those things, and we said it from the beginning, you want to make sure that you understand the terms and conditions, particularly of the lease agreement that's in place, because I think that's what quite crucial in when you're buying a property that is a tenant. And in the event where there is no written lease agreement, as Marius said, has advised, do get something in writing so that you are very clear that the current owner, so the seller, stipulates what the terms and conditions are, and that the tenant also signs to those particular terms and conditions, so that in the event where you'll be taking over that lease agreement, as it were, you're also very clear that this is what you're signing up for, and these are the stipulated terms and conditions. So, Marius, as we close up, any final tips for both the buyer and the seller who are about to buy or certainly about to sell a property that has a tenant in place?
Yeah. My final thought is this: is that you and I in the property space, this is easy, right? We do it in our sleep. But there's a reality out there. And that reality is that buyers and sellers of all walks of life and all levels of education and all levels of business, they just don't understand this process. I mean, that's the reality. So my final thought is, there's lots of conveyancers out there who will happily help you with these transactions and vet the clauses for you and make sure that you've got the correct clauses in place. Just ask, ask and you'll get help from a conveyancer. Ask up front, do it right, and then save yourself the pain later of getting it wrong.
And that's such a great place to leave it at, Marius. Thank you so much for joining us this evening.
Absolute pleasure. Thanks for having me.
And that is Marius van Rensburg, who's a partner at Schindlers Attorneys. And that brings us to the end of the Private Property Podcast with myself, Uzamandungwa Khumalo. I'll be back on your screens tomorrow evening at 7 p.m. As it is a Monday, Chad will be taking over at 8 p.m. with the Home Shoppers Show. Until then, hope you're staying home and staying safe.